Facing foreclosure in Florida today looks different than the 2008 crash. The pressures driving families into default are more complex and catch homeowners by surprise. Modern defaults are frequently driven by property insurance premiums jumping 40 to 60%, alongside massive HOA special assessments triggered by new structural safety laws. Because property values climbed so rapidly over the last few years, you likely have significant equity in your home. However, many owners lack the immediate monthly cash flow required to absorb an extra $500 to $1,000 in forced housing expenses. This creates a tight strategic window. You must decide whether you are fighting to keep the property long-term or fighting to extract your equity and exit. Selecting a definitive goal, retention or liquidation, is the first step required before you can deploy any legal defense effectively. Florida is a judicial foreclosure state. This means your lender cannot simply seize the property. They are legally required to file a lawsuit and prove their case to a judge. This timeline breaks the Florida foreclosure process into 7 distinct legal stages. It begins with missed payments and a 120-day federal wait. After a breach letter, the lender files a lis pendens. The 20-day answer window is the primary turning point, beginning once you're served. If you do not file a written response within those 20 days, the lender can move for a default judgment. This compresses the entire timeline to just 6 or 8 months and removes your ability to negotiate from a position of strength. Participating in this window changes the nature of the case. It shifts the lawsuit from an automated process into a structured negotiation, where you control the pace of the litigation. Filing a formal answer to belie the lender's allegations shifts the case into contested discovery. Both sides are then required to exchange evidence and documentation. This procedural step requires adherence to court rules, but it successfully expands the foreclosure timeline from a few months to anywhere between 14 and 36 months. During this period, you can raise specific legal defenses, such as challenging the lender's standing to sue. To prove standing, the lender must provide the original promissory note and an unbroken chain of endorsements. If securitization paperwork is flawed or the note was not properly transferred, the court can dismiss the case. You can also scrutinize the pre-suit breach letter. If the lender failed to provide a 30-day cure period or sent the notice to the wrong address, you may have a valid defense against their motion for summary judgment. Forcing mediation is another tool to halt the litigation process. Many Florida circuits require a lender representative with settlement authority to meet with you, which adds another 60 to 90 days to the timeline. While these procedural tools rarely eliminate the mortgage debt entirely, they create the time necessary to coordinate a permanent financial resolution. The time bought through the courts must be used to execute one of 3 primary financial alternatives. We evaluate these paths based on their impact on your credit, whether you stay in the home, and the overall time required. A loan modification allows you to keep the property with minimal credit impact. However, the lender will require proof of stable income and will typically capitalize any missed payments into the back of the loan balance. A short sale results in the loss of the property and a credit drop of 50 to 130 points. The benefit is cleanly eliminating the debt and securing a waiver of the deficiency judgment. Chapter 13 bankruptcy acts as an emergency measure to stop an auction. While it saves the home, it causes significant credit damage and requires a court-mandated repayment plan lasting 3 to 5 years. Each option involves a specific trade-off. You are essentially choosing whether to prioritize your credit score, your time, or the asset itself. The Florida system provides significant protection for active participants. Your success depends on matching your specific financial reality to the correct strategy. This decision map pairs your goal with the appropriate tactical toolkit. If you are a retention strategist with stable income, your path is to file a timely answer, challenge standing, and use mediation to pursue a loan modification. Warning tone. Chapter 13 bankruptcy should be reserved for cases where income is tight and you need an emergency stop before a scheduled auction date. If you are a pragmatic liquidator facing unmanageable HOA or insurance costs, you still file an answer to secure 6 to 12 months of legal protection. If you have equity, use that time to sell the home on the open market and pocket the proceeds.
If you are underwater, execute a short sale to prevent the lender from pursuing a 20-year deficiency judgment. Your ability to utilize these options depends on your right of response. That window opens the moment you are served with the lawsuit. By choosing a defined objective and filing a timely answer, you create a structured, controllable path through the litigation process.